Welcome back, class. We've officially reached the halfway point in the semester, and we still have a lot to cover. I hope you guys have been paying attention. Today, we're diving into the 4th, 5th, and 6th Amendments, the backbone of our legal protections in the criminal justice system. We'll explore 3 landmark Supreme Court cases, Mapp v. Ohio, Miranda v. Arizona, and Gideon v. Wainwright, and we'll discuss how Black Americans have shaped criminal justice reform, pushing back against a system that has historically failed us. Now let's get into it. Let's start with the 4th Amendment, which protects against unreasonable searches and seizures. Now, on paper, it sounds pretty straightforward. Law enforcement needs a warrant to search your home or personal property. But in practice, it hasn't always worked that way, especially for Black Americans. In 1961, a Black woman named Mapp was at the center of a case that would change how the 4th Amendment is applied. Police suspected her of harboring a fugitive, but they never had a warrant. Instead, they forced their way into her home, searched her belongings, and found materials they deemed obscene. She was arrested, convicted, and sentenced, all based on evidence obtained illegally. Mapp took her case to the Supreme Court, and the ruling was clear. If evidence is obtained illegally, it cannot be used in court. This became known as the exclusionary rule and applied to state courts as well. From this rule came a doctrine known as fruit of the poisonous tree. Any evidence obtained from an illegal search or arrest, even indirectly, is inadmissible. Now, let's keep it real. We know plenty of cases where this has happened, even after it was declared unconstitutional. From stop and frisk policies in places like New York to racial profiling and traffic stops, Black Americans are still disproportionately targeted for searches and often without cause. Next, we have the 5th Amendment, which protects against self-incrimination. Basically, it says that you can't be forced to confess to a crime. But what happens when police pressure, intimidation, or even a coerced confession come into play? In 1966, the Supreme Court heard the case of Miranda v. Arizona. A man named Ernesto Miranda was arrested and interrogated for hours without being told he had a right to remain silent or a right to an attorney. He confessed without knowing his rights and was convicted. The Supreme Court ruled that suspects must be informed of their rights before interrogation. This is why today police say,
"You have the right to remain silent. Anything you say will be used against you in a court of law. You have the right to an attorney during interrogation. If you cannot afford an attorney, one will be appointed to you."
This decision gave us what we now call Miranda Rights. But here's the catch. Just because the warning exists, it doesn't mean it always gets followed. In many cases, Black suspects have been interrogated without being properly Mirandized. There are countless instances where people, especially young Black men, have been tricked into confessing to crimes they didn't commit. And when we look at wrongful convictions, Black defendants make up nearly half of all exonerations. That's not a coincidence. Now let's talk about the 6th Amendment, which guarantees the right to an attorney. Now it seems simple. If you can't afford an attorney, one will be provided to you. Well, not always. In 1963, a man named Clarence Earl Gideon was arrested for burglary. He was homeless and he couldn't afford a lawyer, but the state of Florida refused to appoint one for him. He was forced to defend himself and he unsurprisingly lost. Gideon sent a handwritten letter to the Supreme Court to appeal his case. The court ruled that anyone accused of a felony has the right to a free attorney. He eventually was acquitted after a second trial. This case was a win for due process, but in reality, public defenders are overworked and underpaid, often handling hundreds of cases at a time. For many Black defendants, this means rushed plea deals, minimal defense, and wrongful convictions. And let's not forget jury bias. The 6th Amendment guarantees an impartial jury, but Black defendants are often tried by juries that don't reflect their communities, making it easier for bias to creep into verdicts. Black Americans have been fighting for justice in the legal system for centuries. Let's talk about a few ways they've led change. The NAACP Legal Defense Fund fought wrongful convictions and biased sentencing. The Innocence Project has overturned hundreds of wrongful convictions, many of them involving Black defendants. Khalif Browder's case, a 16-year-old jailed for years without trial, sparked national conversations about pretrial detention and bail reform. And today, we see the movement continuing with calls to end qualified immunity, stop cash bail, and reform public defense. Now, we've covered a lot today: the 4th, 5th, and 6th Amendments, landmark Supreme Court cases, and the ways Black Americans have fought back against injustice. But now I want to hear from you. If you could change one thing about the criminal justice system, what would it be? Let's get the conversation started in the comments. Next class, we'll be tackling the 8th Amendment, mass incarceration, and the death penalty. You won't want to miss this. See you then.